in response to, and counsel, if you want to approach to see this, it looks like they were writing a question underneath my response, and then they put it on a separate sheet. So it reads, yes, if Noel Carter was treated with excessive use of non-deadly force, is that a justifiable reason for non-guilty for count 4? There's no such thing as excessive use of non-deadly force under the law. So that question is interesting to me.
Gotcha.
I'm sorry, can you hear me?
Yes, I'm saying just go back and point to the instruction that we're talking about earlier. Leave that right.
State request is identified in paragraph 1.
Okay. Okay. Go ahead.
Legal answer to the question.
Right.
Clearly.
It is.
The only, I appreciate everyone's hesitancy. Maybe I guess I would ask the question, why would you not answer that question? Clearly, that defense legally does not apply to that. Before I say anything else, I guess I'll pose that question.
Okay. What says the defense then? Yeah, no, that's fine. Yeah.
Can we take that?
Yeah, that's fine. I just have to keep those for the record. Can you just leave the question in here for me? I'm not suggesting it's going to get lost, but
Can she take a picture of it?
you can't take photographs in the courtroom unless you're a member of the media.
Yeah.
May I approach, Your Honor?
Yes. Thank you, ma'am. Okay. What says the defense?
Your Honor, we would ask that you read the entire instruction with regard to justifiable use of non-deadly force rather than just a portion.
And why do you believe that we need to read the entirety of the instruction when the only confusion they appear to have by their question is just whether that instruction applies to count 4?
Well, the reason that I would ask them to do that is because I think my own system or to tell them, listen, this is the only portion of the instruction that you need to pay attention to. It's our contention that they have to pay attention to the entire instruction, not just a portion.
What says the state?
This is a legal question. The jury has a clear answer. So we could ask if that's it.
Okay, so it appears to me from their original question and their response to my question, or our question, that their confusion is whether that instruction applies to count 4. And so I'm going to instruct them that the justifiable use of non-deadly force instruction only applies to count 1 and count 2. And I'm going to redirect them to that instruction. They have the instructions in the jury room with them. They can read them. The only question that I have is whether you want me to bring them in to give them that instruction or write it on a piece of paper.
Well, first we object to it.
Well, we understand the court's ruling. Obviously, just to be clear for the record, we'd state our objection to the court.
That's fine.
Doing that, and I would ask that they be brought in.
Okay, that's fine. Let's bring the jury in.
She's directed to find you guilty.
Deputy, could you ask them to bring their set of jury instructions with them? Okay.
Say you look at that part. Because she's not coming from. Yeah.
He can resist excess force. And that's just, that gives you it's instruction.
Sure, that's fine. Come on up. Okay, members of the jury, you had sent out a question originally, and I responded with a question so that I could be certain what you were asking for. And your response back to my question reads, for the record, yes, if Noel Carter was treated with excessive use of non-deadly force, is that a justifiable reason for not guilty for count 4? And in response to your question, the only thing I'm going to do is redirect you to the instruction that you have already been given on justifiable use of non-deadly force. And at the beginning of that instruction, it reads, it is a defense to the crimes of resisting officer with violence, count 1, and battery on a law enforcement officer, count 2, if the actions of Noel Carter constituted the justifiable use of non-deadly force. Right. And so with that clarification, you may retire to the jury room to continue with your deliberations. Thank you. All rise, please. Okay, I'm going to hand those questions to the clerk and ask that those be made part of the record, and then we will be in recess until the jury returns with another question or a verdict.